ladies and gentlemen, those of you who are gathered here in the sanctuary at Cave Hill, and those of you who are online, whether you're viewing it live or you're viewing it at a later time, I do want to welcome you to our session this evening. It's going to be presented by one of our sisters who's an attorney at law, Mrs. Shamora Scott Springer, and it is titled Understanding Wills, Estates, and Probates. This is an area that causes a lot of confusion to persons, and it results, quite frankly, in persons not being properly prepared for when they're passed, and how to distribute their property, how to distribute their assets, in terms of even how to plan, because a lot of times, we just consume all that we acquire, we spend it out, and we don't do what is encouraged in the Bible, lay up something for those who are coming behind you. And so we are hopeful that this session will educate, it will titillate you, and it will motivate us all to be better stewards of the finances and the assets that God has given us. And before I ask Mrs. Scott Springer to come to the front, I just want to invite you all to stand, bow your head with me, and let's commit this session to the Lord in prayer. Our precious Heavenly Father, we are so grateful that we get to come to you as the fount of all wisdom. We thank you even now for our sister Shamora, and for enduing her with wisdom so that she can share it with us at this point in time. Even now, Father, we pray that as we sort of do this studying to show ourselves approved in how we manage the things that you give us, I pray, Father, that it would be a time where your Spirit is also felt, that we would also get confirmation for the things that you want us to do, that you would lead us into right paths and right living, Lord, so that we can also store up a heritage for those who come after us, and we can do your kingdom justice. Father, we give you thanks for those who are still on their way here, those who will listen to this session, and I just ask, Father, that you continue to be with us as we go from day to day. These things we pray and ask. In Jesus' name, amen. All right, so for those who are in, you can have your seats. For those who are in the building, our main exit is the one that you came through, and we do have washrooms to your right. So if you have to go, please use the ones to your right. And as Mrs. Scott Springer conducts the session, she has allowed us some liberty. There will be a question and answer session afterwards, so you can jot down. But if you do think there's something that you really don't understand or you want a bit of clarity on immediately, there is a mic right in the center of the building. You can just indicate and you'll be able to have the floor. For those who are watching online, we'll be monitoring the stream. So if there is a question that you need to have answered, just type it in the chat, and we will bring it to Mrs. Scott Springer's attention and have those questions answered. So ears open, mind open, let's be present and have a great session. Good afternoon, ma'am.
Thank you, Sister Francine. Good afternoon, everyone. Great. So this afternoon, I am presenting on a topic, a complex topic actually, wills, understanding wills, estate, and probate. We will only be scratching the surface because it is quite complex, and this is an area that takes law students an entire semester to, major. So before I go on, I just want to say that I am not giving legal advice. The information shared here is only for educational purposes. Should you require specific legal advice, I would advise that you consult your attorney or seek any attorney at law. Okay? Great. So, Ecclesiastes 3 verses 1 to 2 declares that there is a time for everything and a season for every activity under the heavens, a time to be born and a time to die. As morbid as it sounds, we all will die. Physical death is a certainty of life for all of us, unless we are one of those believers who are alive and remain at the time of the rapture. The psalmist David puts it this way in Psalms 89, verse 48. Who can live and not see death? Or who can escape the power of the grave? So while death is not something we like to think about or talk about, we as believers need not despair, because there are crowns awaiting us in the afterlife. I am a member of the women's ministry, and our theme for this year is crowns and crown jewels. It comes from the 6 crowns mentioned in the Bible, 1 for the present, which is the crown of hope, and 5 crowns for the afterlife, which are the crown of life, the crown of rejoicing, the crown of righteousness, the crown of glory, and the incorruptible crown. So because of death's certainty, it is a good thing to prepare for it. And part of that preparation, as a matter of fact, many persons would have prepared in the past by making advance directives in the form of a will. The Bible, I'm not preaching, but because there is so much, it's interconnected, I have to make reference to the Bible. The Bible gives some examples of persons who would have planned ahead. When King Hezekiah was ill at the point of death, God sent the prophet to him with a message. This is what the Lord says: put your house in order, because you are going to die, and you will not recover. That's in Isaiah 38:1. And so today, making a will can be considered part of what we say putting one's house in order. So let's delve into it. Today I'm going to be looking at what is an estate, what is a will. I hope you brought some pen and paper. It's a lot of information, but just take what you need and leave the rest. What is a will? Who can consider making a will? Why you should make a will? We're going to talk about intestacy, the requirements for the creation of a valid will, how to get started on making your will. We're going to talk about appointing executors, what types of properties you can give away in a will, revocation of a will, or how to cancel a will. If you even need an attorney at law, because some people think we are here just to take your money. So we're going to talk about if you can do it on your own, the disadvantages of doing it on your own, and what is probate, how to get probate, and what happens after probate. So it's quite a lot, but I'm just going to skim the surface. I anticipate a few questions towards the end. Okay, so when a person dies, everything they own forms part of what we call their estate. So this could look like real estate or land. If you have a house, the contents in the house, anything you own at the time of your death is called, that's your estate. Money in the bank, some people may not have any, but if you do, all of that forms what we call the estate of a person. So we are all stewards of the things God has given us. And as good stewards, we would want to put things in order for the persons who we are taking care of. Not so? Right. Because I have seen far too often where persons die without leaving a will, and their family members, persons who may not have spoken to them in years, they come and they want to claim, oh, mommy told me that the house in the back, I can have it. And then another sibling comes and say, oh, but she told me on her deathbed I will have it. So you want to make sure that there's no confusion when you leave. And if it's one thing I have understood that persons really fight about when people die is land, because land has value. All right? So what is a will? A will is a legal document that lets you direct how your estate should be distributed. Remember we said the estate is all that you have when you die, all your assets and so forth. So the will tells persons how you want those things to be dealt with, how you want them to be distributed. It sets out who will benefit from the assets. It also sets out how you want any minor children to be cared for or any specific funeral arrangements. Next slide, please. So, who should consider making a will? Right. So, if you are married, you might want to consider making a will, because your spouse is someone who is so close to you. Let's say you want to give somebody else something, you should probably put that in the will. So it's important that I'm not saying that you're disinheriting your spouse, but if you want to give any other gifts, you would want to put it in your will, because the next person who naturally benefits from your estate, if you die without a will be your spouse. So if you have any specific gifts that you want to give, you put it in your will. So your spouse, if you are married, you should make a will. If you have kids, you should consider making a will, or children, because after your spouse, your children will likely inherit your things, and that is if you die intestate. I'll come to that in a minute. So if you are married, if you have children, and if you have any money in the bank or any assets, you should consider making a will. Next slide. So I have a little graphic here. This is Stephanie. Stephanie is 28 years old. Stephanie is 28 years old. She just graduated from the University of the West Indies. She is single. She doesn't have any children, and she's not married. She's single. But she has a ton of student loan debts, a lot like some of us, who would have gone through the system and gotten a degree and so forth. Do you think somebody like Stephanie should consider making a will? Remember, she's single. She has no children. She has no assets. She just come out of university, and she has a ton of debts. No, Stephanie should not even go back to the other slide, please. Stephanie should not even think about making a will, right? Because what does she have to give away? The debt? I mean, I would gladly give away my student loan. But she has nothing to give away. So Stephanie doesn't need to sit and think about, oh, I need to make a will. She has no children to look after. So somebody like Stephanie does not need to make a will. So if you have dependents, if you have children, if you are married, you would really want to sit and think about, what am I going to do with these assets, or who am I going to give away my things when I pass away? So somebody like Stephanie need not consider making a will. All right. When you should make a will. No one knows when he or she will die, right? But we do know that man has determined days, and the number of days and months we don't know. Only God knows this. Because of life's uncertainty, it's always better to be prepared. As a guide, one of the mottos was always be prepared. Be prepared in the event that today and tomorrow you're not here. You want to make sure that your family and your friends are well taken care of. So because we don't know when we will die, it is wise to put our house in order. So, you may ask why I should make a will. We are good stewards, right? God has given us a lot. He has blessed us with a lot. But I'm going to tell you what would happen if you don't make a will. So I'm going to answer this question in the reverse. So some of the people who you would like to provide for may end up not receiving anything. Like I said, when you pass away and you make a will, you specifically say who you want to benefit. But if you don't, the laws of what we call intestacy, or somebody dies intestate, that means that person dies without a will, those laws will apply. If you don't make a will, you don't know who would be dealing with your assets. When you make a will, you're able to appoint an executor to say, this is somebody I trust. When I pass away, I want you to be in charge of my affairs to ensure that my kids get this. But when you die without a will, you don't get that say. In fact, the laws of intestacy, as I said, applies, and the state will determine who gets what. Okay? You could go to the next slide. So a person can die with a will or without a will. When a person dies without a will, we look at it as that person did not put their affairs in order, like I said. When a person dies with a will, we see it as that person was prepared for death. Okay, and just ignore that slide. I'm not sure what's happening there. So according to the laws of intestacy, this is where you die without making a will. There is an order of priority as to who can apply to get into your estate, who can apply to access your things. First, the first person is your spouse, if you have a spouse. Next in line would be your children. Then it would be your mother, your father, and then if you have any brothers and sisters or grandparents, uncles and aunts. So there is a hierarchy, right? That is if you die without leaving a will. But if you make a will, you can specifically appoint what we call an executor, and that person, upon your death, would apply to get into your estate. If I'm moving too fast, just stop me. If you have any questions, just raise a hand. Right. So, in the case of intestacy, where there is no will, where you did not make a will, the administration and distribution of your property is governed by the laws of Barbados. So if an intestate person, if an intestate person leaves a spouse but no children or next of kin, the spouse is entitled to the whole estate. So if you have a spouse and no children, your spouse gets everything. This is if you don't have a will, right? If you have a spouse, if the surviving spouse has no children, but there is a named next of kin, the spouse is entitled to 2/3 of your estate, and the remainder goes to your next of kin in equal shares. That's if you have a named next of kin. If you have a spouse and one child, the spouse takes 2/3 of the estate, and your child takes 1/3. If you have a spouse and more than one children, the spouse takes 1/3 of your estate, and the children will divide up the 2/3 remaining. So it gets quite complicated when you don't leave a will, because then now we have to what we call in the estate. The attorney has to write to every financial institution to see if you had bank accounts there. We have to do searches at the registry to see if you had land. When we have the full value of the estate, that's the only time we can know how to split up the estate. So it gets very complicated when a person dies without leaving a will. So it's always best to put your affairs in order, and you tell people, this is what I want when I die. I want Sister Francine to get this. I want Greg to get this, and so forth. So it gets complicated, okay? Right. Yes, please. We have a question. Good afternoon.
Right, good afternoon again. I have quite a few questions on my list, but I think just to clarify this, not just for myself, but others. So I think right now, the most popular time that persons will name a next of kin is when they go into a medical institution. And in that field, we have lots of problems because people's next of kin change every time they have a quarrel, and they forget that that's who they put as the next of kin. Sometimes you call persons, oh me, I don't talk to that person for 12. So can you, in terms of what you've just explained with intestacy, how good does that stand up? How do you just go about, can you just name the next of kin? Does it have to be in your, because this is intestacy, right?
Intestacy.
So where do you find this next of kin? And in medical, where do you find the next of kin?
Yeah. Usually, like you say, it usually applies to, okay, medical situations or financial institutions. Mm-hmm. Okay, have you ever gone to, let's say you were taking out a life insurance policy, and that may not be the best example, but Usually, if you have, let's say you have a your next of kin, and you have to write a name or give them a name and a contact information. So usually that is how we're able to glean next of kins, because the reality is, and that can get quite complicated, because you would think, let's say a man is married, his next of kin could naturally be his spouse, but that isn't always the case. So that is why it gets very complicated when a person dies intestate, because we now have to basically do research on his life before, who was he closely connected to. But generally, the next of kin is named, written in a document for a specific purpose. I hope I answered your question.
Yes, you did, but it's very, very tricky.
It is. I
Very
do
tricky.
admit it is. It is. Yes. And if you are, wait, 1 minute, Sonia. If you are naming a next of kin, you should at least tell that person that I have nominated you to be my next of kin. If anything were to happen to me, I give them your number. Is that okay? You know, you don't just put somebody, because I could be there out of the blue and I get a call. I'm Shamora, you're the next of kin listed here on who? So it may be wise to contact that person before you put their names down as a next of kin.
Hi, good evening. Is it illegal if I have somebody in the hospital and suppose they put me as the next of kin, anything happened to them, right? Is it illegal for some person to go and say they're the next of kin and bring that person out of the hospital without documentation, knowing that I have been the person that has been documented to be in charge of that person? Is it illegal?
That's interesting, because on what authority would the other person
None.
have
None.
Well, I think that would be up to the medical institution, because if somebody is listed as a next of kin, I can't see how somebody can just come and say, I need to remove my relative, because, they won't have authority to do that.
Okay.
It may not be, I'm trying to see which statute that may fall under, or whether it is illegal, but there may be a case there or a claim that can be brought. Just need to figure out on what is the cause of action. Yes, Sister Beverly?
Good afternoon, everyone.
Good
Is there such a thing as a living will? I mean, or just power of attorney?
Yes, there is in some jurisdictions, but I don't think Barbados recognizes living wills. That's where a person makes a will throughout their lifetime for the assets to be distributed while they're alive.
Yeah.
But I don't think it is recognized in Barbados. I just did some research on it a few weeks ago, and I was told that no, it's not recognized here.
Okay.
Megan, can I write a will, what I want at my death, right? And keep it at home without, we always hear about lodging wills, going to the attorney. Do I have to go to an attorney
No, you don't.
to get a will lodged, or can I stay at home and write out something and get somebody's signature to it, and put it somewhere in a safe or whatever, and could that stay up in court if anything happens to me?
Yes, you can make your own will. You're actually jumping the gun, because I have a whole wealth of information on that. You can make your own will. Usually when the attorney makes your will, we would lodge the original at the registry for safekeeping, so that when that person passes away, we go and we retrieve it. We don't lose it. But persons do make their own wills at home, but it can be very problematic, because you may think that you're doing it the right way, but there are certain formalities that we have to comply with for it to be valid. So it might be a will, but it might not be valid. All right? Right, so I'm going to go there now. So there are certain requirements for the creation of a valid will. You must be 18 years or older, or you could married or have been married. You are eligible to make a will. And importantly, you must be of sound mind. So the person who is making the will is known as what we call the testator. That person must have the mental capacity to make a will. When we say that, we mean that they must know and understand and approve of the contents of his or her will. He must be able to recollect his property. He must understand that he is giving away his property to more one or how many persons. And he must do it of his own genuine choice, free choice. He must not be unduly influenced. Okay? Now, certain diseases of the mind will disqualify persons. For instance, if a person has dementia or schizophrenia, or if that person is on drugs, that can disqualify someone from making a will because they are deemed as not being of sound mind. A person with dementia can't remember a lot of things. They can't recall. They can't sometimes recall that they just put a cup over there, you know. So once you are of sound mind, you understand that what you are doing, you understand the assets that you have, you know of the assets that you have, you know who you want to give it to, you are able to make a will. Now, we are cautioned to exercise a lot of care when we are making wills for elderly persons. I have heard stories, I have not seen it for myself, but I don't know if Sister Francine can attest to it. I've heard stories where persons are in the hospital and what appear to be relatives would come, like that person is making their way out, and relatives would come and they would bring a piece of paper and you would see them trying to get mommy to sign something. That person may not be of sound mind. That person may not even understand what it is, this paper, this child bringing for me. What is this? So persons try to take advantage of the elderly. So we are cautioned to be very careful. Now, in my situation, when I think that somebody may not, it is questionable whether that person is of sound mind, I would send them to a physician or medical practitioner. We ask to have a note. Let the medical practitioner assess that person. Let them deem them fit of sound mind, because that's not our specialty. So a doctor, let them see a doctor, let them be assessed. The doctor will be able to say, okay, this person is fully compos mentis, they are functioning well, they can make a will. So that is how we protect ourselves as attorneys at law. If we think that something is questionable, we ask them to see a doctor. A deaf or a dumb person can make a will once he or she understands what is written down. The will must be in writing. It must be signed at the foot or the end of the document. And it must be signed by the testator or the person making the will in the presence of 2 witnesses. So it must be signed at the end. It must be in writing. This writing can be handwriting. It can be typed. But it must be signed by the testator, and it must be witnessed by 2 persons. So, Sister Sonia, if you're making your will at home, these are some of the formalities that you have to comply with. Without these, it will not be a valid will. So when you die and your family wants to probate that will, there will be questions from the registry as to whether or not this was a valid will.
So you're saying that if I decide to go that route, just suppose I want to go that route to do it at home, would I have to get a doctor to say at that particular time I was in my right mind as I would have written the will?
No, you don't necessarily have to.
Right.
But of course, if it is contested in the end, let's say one of your relatives contests the will. When I say contest, I mean they question the validity of the will. What proof do you have now to say? What proof would they have to say, well, when Sonia made the will, she was thinking right, she was of sound mind. So it can be contested.
And there must be at least 2 signatories to this.
Yes.
Okay.
You must have 2 signatories present with you at the time that you're writing. So you sign, they watch you sign, then you watch them sign. So yes, there must be 2 witnesses signing at the bottom of the will.
Question from Auntie Joan here. If the major the major, I can't remember the word now, the person who stands to benefit the most, can they be one of the signatories?
So no, I was getting to that, but if you are a beneficiary within a will, you cannot be a witness to the will, right? So let's say I want to leave something for Greg. I can ask Greg to come with me to a lawyer to witness my will. He will be disqualified. The will be valid, but he will be disqualified. Whatever gift that I was trying to give him, it would not stand. So a witness can't be, a beneficiary to a will can't be a witness in a will. All right? All right, so let's get started on your will. So how do you go about making a will? So you make a list of all of your assets and your liabilities. You make a list, so it's one list. You can split it in half. You put on one end, you say, these are my assets, these are the things that I own, and these are my expenses or my debts, right? So you make a list, and you check it twice, but that is how you start. The list can include anything that you want to give. So let's say you want to give a family heirloom or money in a bank account or money in a safety deposit box. You can put that as an asset. Anything that you want to give, you put it on that list. And remember to put as well whatever liabilities you have. If you owe a bank or whatever, you put it on that list as well. Right. You also need to choose an executor. Now, the executor is the person who is responsible for administering your estate when you pass away. When I say administer, I mean the person who will make sure that your wishes are carried out. So it has to be somebody who is still alive. You are free to name your spouse, an adult child, or a trusted friend. And I say trusted because it has to be somebody who you trust your life with, literally, right? You want to name somebody who you know will take care of your business when you are gone. It can be, you can have more than one executor. You can have two or sometimes four, but it's not necessary to have more than two, right? If your estate is complicated, or if you have a lot of assets, if you have a lot of wealth, you may want to include an attorney at law as one of the executors, right? Or somebody like who has experience in a particular field, like an accountant or financial expertise. You may want to also name that person as an executor because that person has specialist knowledge and they can help administer your estate better. Right. So it is important to include in your will a clause that gives your executor the power to pay your bills and deal with debt collectors. Because, yeah, the wording of the will must allow the executor leeway to take care of any related issues that aren't specifically outlined in the will. So that's why, Sister Sonia, if you're making a will, you may not know how to craft or how to word certain clauses that would help your executor in the future. You might just be listing all your assets. I want them to go to X body, but you may not capture what a legal mind would capture, right? Right. So, appointment of the executor. Okay. So the executor, like I said, can be somebody you trust. But if you have a minor child, you may also want to appoint what we call a trustee. That person would basically take care of the child or look after the child's interest upon your death. Now, an executor can be both a trustee and an executor. So you can have one person as the same, right? Trustees, for instance, if you have a child who's 12 years old and you want to ensure that at the age of 18, you have some monies in a bank account and you want them to be able to access that money upon the age of 18, not at age 12, because they may not know what to do with that money. The money is specifically for them to go to university. You may want to set up a trust, which is a different instrument, a trust to take care of your child, so that that trust would say, upon the age of 18, I want Sandra to access bank account at XYZ. She has to use the monies there for a specific purpose. I want to go to university to further her education. So now if you set up a trust within a will, then you have to have a trustee, which is the person who has to ensure that upon the age of 18, Sandra gets that money to go to university, right? So it can be both, the same person can be an executor and a trustee. Now, the executor has very wide powers. So that is why it has to be somebody you trust. They have the power to sell properties in your estate. They have the property to invest your properties or any of your assets. And they have the power to maintain the property. So that is why caution is taken when you're choosing your executors. You have to make sure that it's somebody you trust. All right. What can be included in your will? So you can include any real property. I'm sorry for the size of the slides. Any real property. If you have land or any lease, you can include that. Any interest or shares in a company can be included. Property that you co-own as a tenant in common. Now, that is different from joint tenants, right? I don't want to get into the specifics of it, but basically, if you own that property as a tenant in common, you can give it away. That means that if you die, your share in that property goes to your children. It doesn't go to the other co-owner automatically. It will go to your children. So if you have shares like that, you can include that in a will. Ownership like that, sorry. Any money, any funds from a life insurance policy that has no beneficiary, you can include that. Any movable property like cars, jewelry, yes, you can include those as well. So, generally, a testator or somebody who's making a will has freedom to give away as he pleases, but there are some exceptions. You can't give away property that you do not own. You must own it. It might sound funny, but persons would want to give away things that, okay, they're affiliated with, but they don't own it. So you have to own the property, right? Let's say you have a life interest in a property. When I say life interest, I mean that you are allowed, let's say you are allowed to live in a property for all of your life. When you die, your interest ends there. You can't pass it on. So you can't put that life interest in a will because it's only for your lifetime, not another person's. So you can't put that in a will. Also, there are restrictions when the person has a spouse or a child. If somebody dies and they leave a spouse and a child who is minor or who is incapable of maintaining him or herself because of some mental or physical disability, you have to take care of that child and that spouse in the will. Any clause that disinherits them is void. It cannot stand. Right? If somebody dies and they leave a spouse but no child, the spouse is entitled to 1/2 of the estate. If a surviving spouse the spouse's right takes priority. So the law takes care of spouses. Now here in Barbados, you have common law spouse, and that's another story. So you have to make sure your spouses are taken care of in your will. I know I have questions there. A surviving spouse has 6 months from the date of probate, I'll get to that, to take what is given in the spouse, in the will. So you have a window within which you should go to the court, not go to the court. Let's say you have land, after the 6-month period, it's gonna be, the law says that you should try to access whatever is given to you within that 6 months period. If a man and a woman have been cohabiting for a period of 5 years immediately before the death of either of them, the common law spouse, as we say, has the right to that person's estate because they're now deemed the spouse. Any questions there?
This common law thing, is it a particular amount of years that the persons have to be together?
5 years,
5 years.
at least.
Okay. What about children, outside children? You know, from time to time, people have outside children.
What is
And
it?
when a person dies now, I'm talking about underage children. I'm not talking about children who are above the age, right? Does the law make provision for those outside children? You talk about children who are challenged or whatever, but those outside children,
Yeah.
does the law make provision for them?
Yes. Once the deceased person recognizes that child as their own, he or she is deemed to be a child of the deceased. Of course, it can be challenged. Let's say there are other siblings involved, and I don't think that, let's say, let me use myself. Let's say my father had outside children, and let's say he gives one of the outside children something that I wanted. I might be tempted to challenge whether or not this outside child is my sibling. So you would find situations where persons are asking the court to determine whether or not that person is a child of the deceased. Then you have to do a DNA test to see if they're related, and it can become contentious. So yes, you can provide for your outside children as long as you have recognized them or accepted them to be your child, right? During your lifetime. So if I recognize Sonia to be, not Sonia, but if I recognize somebody to be my child, I have been providing for them while I'm alive. I took care of them at some point. I gave them money. They know that I am their child. I have their name on my my name is on their birth certificate. That person is deemed to be that, the testator's child. And you can provide for them. Yeah? All right. So a will could be challenged. It can be, cancelled or altered during the lifetime of the testator, the person making the will. Next slide. Next slide. Right. So if you have two wills, the most recent one is the valid one, and that's the one that will stand. So if you want to make a change to your will, you can do two things. You can make another will, or you can make what we call a codicil, which is you are making a change to a clause within your original will. So you can have many wills during your lifetime, but the one that you made closer to the time of death is the one that will stand. So the most recent one will revoke the former one, right? Okay, so marriage revokes a will unless it is stated in the will that it was made in contemplation of marriage. So let's say Stephanie gets married. Stephanie makes a will before she gets married. Let's say she comes into some funds. She gets a big job and, she starts thinking about life. She makes a will. 5 years later, she meets a guy and she decides to get married. The will that she would have made when she was single will no longer be valid. She now has to make a new will unless she made that first will in contemplation of getting married to this guy, specific guy, 5 years down the line. So marriage automatically revokes a will. If you get married, if you're single and you get married without contemplating marriage, it will be revoked. You can ask. You can ask. And I think a lot of young persons think that wills are for old people, but that's not true. If you look around, you would see the way how life is going. Persons are just dropping, passing away. So a lot of young persons are actually thinking with the future in mind, and they're thinking, okay, I need to put my affairs in order in the event that something were to happen to me. A gift to a former spouse is revoked upon divorce, but the will itself is not. So the will remain valid, but any gift that you would have given to your ex-husband or whatever, that would be revoked, right? So, and that is why it's so important that you always update your wills. You would update your will if there is a major life event. Let's say a spouse passes away. You may want to change the will to give that gift that you would have given to your spouse to somebody else. Not too hard, Pastor Kwesi.
No. I just want to get this one right.
Yeah.
So, you have a spouse now. You gift them something, and you divorce. This gift is in the will, right?
Yes. And you have named the will.
And
you have named the person as my spouse. I give to my spouse, brother Greg Springer, XYZ.
Good. And then you die after you got divorced, and you have this will that is still there. Your estate takes control of the entire will, that is what you say, and whatever is inside that your former spouse had is no longer theirs?
Right. A will, yes. A gift to a former spouse is revoked. That's upon divorce. So did the person divorce? Did they divorce?
Yes, the person divorced and so on.
Yeah, that gift, you should have altered that gift at the time that you divorced that person. Because that person is no longer in your life. So let's say you divorced that person 5 years ago. Mm-hmm. He went his way, you went your way. 10 years later, you pass away. You now have to contact him to say, the executors will contact him to say, there's a will here that your ex-wife made and she left so-and-so to you. The law says that it is, the gift itself is revoked. It's not valid.
Suppose your intention was just to leave the person in the will, even after you divorce.
Oh. Well, I've never really thought about that part. You could be very kind indeed, and you could want to, but then you can alter the will, because the will would still be reading Greg Springer, my spouse. Mm-hmm. So what you can do is do a codicil, or you change that clause within it, and you can probably put, I give to my dear friend, Greg Springer, my whatever gift you want to give. So you can just alter the will.
In the will after.
Yes.
Okay. All right.
Because then the will normally reads, I give to my spouse, XYZ. So you want to change the language of the will just to ensure that your good friend, even though you are no longer married, still benefits from the will.
All right, just one more question.
Oh dear.
Suppose, I have a number of life insurance policies. What you said is if there were beneficiaries in those policies, you don't have to include them in a will.
Correct.
So automatically on death, what happens is those insurance policies take a life of their own and goes to whoever.
Yes.
Okay.
So let's just make that clear. Once you have a named beneficiary in a life insurance policy, you don't need to include that in the will. You would include in the will a life insurance policy that has no beneficiary, right? Because the insurance companies would automatically should contact the beneficiary to let them know you were named as a beneficiary in the life insurance policy of XYZ. Please come into the office. You need to sign some paperwork because you're to benefit from the estate. But if you have not named a beneficiary, you have to put that in your will because it forms part of your estate. There's no beneficiary attached. Similarly, you would find for bank accounts, different financial institutions have different rules. For bank accounts, if you have a joint account and you have named, let's say you have named a spouse, upon death, that spouse will now take your death certificate to the bank and say, well, she's no longer with us. Please update the account, and the funds in the account you would automatically have access to because you are a joint owner on the account.
Sorry. Again, I like that particular case that you spoke about. I'm going to give it a little bit of a twist. So, I have a nephew that I've helped to look after. And because I'm getting older, I decide that I am going to put my nephew's name on my bank account so that if anything happens. But I also have 5 children. What happens in that case? If I were to die today, would those children have a call on the funds in the bank account, or does it automatically go to the nephew because his name is on the account?
And you would have made a will?
No, didn't make a will.
Right. So, well, if you didn't make a will, but there is a named beneficiary on the account, it goes to your nephew. It will go to your nephew if you have named the person as a beneficiary. But if you did not name anybody, it will go into your estate, and then you have to divide it up with all of your relatives. It would be your spouse, any children you have. They would all form part of who is to get what you have. But if you have named somebody as a joint owner or a beneficiary in an account, that next person would benefit from that account. And I would always advise persons, if you think you are reaching a stage where you are struggling to keep your affairs in order, you should name somebody else or add somebody else to your account. You never know what life may present. You may reach a stage where you can't access or go to the bank, and that person can help you out. But it must be somebody you trust, of course.
Good evening. In relation to the beneficiaries, does the beneficiary, like a child, take precedent over wife or spouse?
You mean if you have a will?
Yeah.
Not if you have, okay, so if you have a will, you can specifically say how much you want to give to the child, how much you want to give to the spouse. But the law says that you must take care of your spouse. Let's say you have property, you can't disinherit your spouse, right? You have to at least leave, I think it was, wait, let me just go back up this slide. I missed it. Right. If you have a spouse, if you leave a spouse, the spouse gets 1/3, and the child gets 2. If you die without a will, right? Half goes to the spouse and you have 1 child, the other half goes to the child. But if you have a will, you can specifically say what you want to go to where. But you can't disinherit your spouse.
In other words, if you have 2 sons, and you have them, you can't have them above the wife in the will.
Yes, you can.
Okay.
You can't completely leave out the will then.
In other words, you could say my 2 sons, I want to get everything. Even though your wife is alive?
No, once your wife is still in the picture,
She have to get something.
Yeah. Unless you have been separated for more than 5 years, if you have been away from your spouse, not cohabiting, you have been separated for more than 5 years, then that spouse is automatically disinherited.
What about, let's say you're in a credit union, and they ask for a beneficiary, and you put your kids, with 5 children also, as beneficiaries, and you don't put, let's say a credit union or a bank account, whatever, got a good set of funds.
You don't have to put your spouse as a beneficiary.
Okay, thanks.
No.
So I'm going to finish. What is the difference between a deed of gift and a will?
Right. So a deed of gift, when we talk about transferring title of a property, it can be done in different ways. So you can transfer a property, a deed of conveyance, or you can do it via a deed of gift, or many other ways. But a deed of gift is basically where you are giving somebody who you hold dear to you property for a nominal value. meaning not much. So let's say you have a child and you want to transfer a piece of land to the child. You transfer it via deed of gift, and really and truly a little amount of money or no money at all passes. So it's done via deed of gift. It's done out of love and affection for the person.
Prenuptial agreements, can there be change?
Prenuptial agreements? Well, that is not exactly within the realm that we're dealing with here. You mean change before you get married? Because a prenup is an agreement that you make before you get married, and you present it to the person who you're marrying. You let them know you can't touch these things. I presume you can change it before you get married. Why would you change it after? I don't know. I wasn't prepared for prenups today. Sorry, I prepared for wills. But I can find out for you.
All right, back to the question of your estates and stuff like that. So persons will go ahead and they will have their life insurance and the bank account and so on. So all of these things that have named beneficiaries, will they be left out of your estate if you die without a formal will?
You can leave them out because you have already taken care of those assets while you're alive. The fact that you named a beneficiary means that when I die, or if anything were to happen to me, these are the persons who I want to benefit. So you don't need to put them in the will because you already have a...
So I'm talking about the persons who don't have a will, but they have a few other policies, accounts, whatever, that have named beneficiaries.
Right, they can access them upon death. So it doesn't form part of the estate.
Right, so it will be everything else that the person
Except
owns
those.
except those
Yes,
things.
correct.
Gotcha.
Correct. All right, so here are some recommendations for making your will. Now, you would want to update your will regularly. When I say regularly, you can choose how often. If it's every 2 years, you want to update this will, just to make sure that it is current. Because what you would find is persons may make a will 10 years from now, and 10 years ago, sorry. And some of the gifts that were made within that will would have lapsed. When I say lapsed, I mean some of the beneficiaries may have passed away, or the gift itself may not even exist anymore. Let's say within the will I said, I'm going to leave my Suzuki Swift to Joy. Maybe when I pass away, the Suzuki Swift may not even be around anymore. So that gift to Joy would have lapsed and Joy gets nothing. So you would want to update your will regularly. Some persons choose to update it, or you can review it every 2 to 3 years. If there's anything in it that you need to change, you can either make a new will or make a codicil, which is to alter one of the terms within the will, right? You want to revisit that will at pivotal moments in your life. So, for example, if you become divorced, or you have a child, or the death of a beneficiary, like I said, you would want to revisit that will and either alter it or change whatever needs to change. Okay? So changing the will is easy. Like I said, you can write a new one to replace the old one, or you can make an amendment in the form of a codicil. Because of the serious nature of codicils and their power to change the entire will, 2 witnesses are usually required to sign when a codicil is added. So ideally, you want to make any changes when you are of sound mind and in good health, because this limits the likelihood that your wishes can be successfully challenged at death, and it avoids decisions made in haste or under intense emotional pressure. So you must still be of sound mind, and you must understand that I am changing my will in order for it to be effective. Okay, next slide, please. So, Sister Sonia, you asked if you can make your own will. A lot of persons think that, all right, I can put on a piece of paper, these are the things I own, I can give them away, and that's it. But there are some problems that you can run into if you do that. It is possible to do it, but it is not recommended. And it's not because lawyers want your money, because it is because we know the law. We have studied the law for years, and there are things in the law that we know that you may not know, and we can prevent some of the problems that can arise. Yes, please.
Right, so we have a question from online. Why is it so expensive to probate a will? That's a question from online.
It is actually, that question is subjective. Okay, so when you probate a will, it depends on the value of the estate. So that person probably has an estate that has a high value. So it depends on the value, or the value of the estate. So, yeah. I think that person is referring to legal fees, right? So the fees that an attorney at law gets to deal with an estate depends on the value of the estate. We follow what is called the non-contentious probate rules. We don't make these rules. These are the rules that are set out for us, and they guide how much we charge in terms of for estates and conveyances and other non-contentious, meaning matters that don't go to trial, right? So it all depends on the value of any estate. That is how you determine fees.
So there are ranges or bands that you have?
Not bands, but okay, so there is, let me see if I can pull it up. But I think the first 100, if the estate values the first 100,000, there's a percentage that comes off. I think it's 1 or 2%. I have to check it. But it's all based on the value of the estate. So the first 100,000, and then I think the next 75,000, and then the next. So yes, there are bands. We calculate it based on the value of the estate, and we apply the rules that were given, set down. That's it. Okay. I'm trying to pull up the non-contentious rules for you. Yes, sir.
So good afternoon. So are these rates made available to the client?
Yes. Well, for my clients, yes. When I am contracted, I usually, well, we're supposed to send out a letter of engagement. In my engagement letters, I would say, these are how the fees are calculated, but at the time of engaging me, I may not know the value of the estate, especially if the person has died intestate, because I now have to go and do all the research to see what assets this person had, how many funds or what they had, in order to determine the value of the estate. But it is always listed in my engagement letter. This is how fees are calculated, and this is how I will be billing you. So they have an idea up front. But when I become seized of the value of the estate, I usually send a statement of account to let the person know, well, this is the value of your father's estate, and based on this value, this is how fees will be calculated.
Is it discretionary on the lawyer's part to inform of these rates, or is there a requirement in law?
I don't know if there's a requirement by law, but everybody needs to know how much they're paying. So it's always wise for us to set out, and even if an attorney doesn't set it out, you can ask, because you need to know how fees will be calculated. You don't just walk into a matter blindly. You would want to know how much you would have to pay an attorney, not so?
Yeah.
Yeah, so
But
most attorneys, you would find that they include it in their letter of engagement. And then, if, like I say, if it's an intestate matter, they would then update the client to let them know, okay, after I have called in the estate, this is the value that I see for your estate, your father's estate, and based on this, this is how we're going to calculate your fees.
Okay. But you know that some people are not that educated and aware, and they might just want the thing over and done with. And don't you think that there should be a requirement rather than leaving it to the lawyer's discretion?
A requirement
To tell the client, this is what you pay based on this, or based on that, based on the value of the land and all that kind of thing, because you know that these things happen.
Yes, I understand what you're saying.
Yeah.
It can be a requirement, but like I said, most attorneys at law would include it in what we call their letter of engagement to the client, to let them know that this is how their fees will be calculated.
I mean, they should.
Well, I do, so. All right, so do you even need an attorney? All right, so Problems often arise with homemade wills, which can lead to delay, uncertainty, and legal costs. So you might think that you're saving yourself money by making your own will, but in the end it can be very costly because there may be problems that would have to be fixed before your relatives can even get into that estate, right? There can be challenges. The will might be invalid, so you might end up paying, your estate might end up paying more at the end than at the beginning if you had just gotten a lawyer to do a will for you. So that is something you have to take into account. The cost of consulting an attorney at law to make your will in the first place, like I said, might be much less than all the problems that they have to fix later on in when you have passed. There may be problems with signing and witnessing. For many homemade wills, the formal requirements may not be there. Like I said, it must be signed at the end of the will. It must be witnessed by 2 persons. So you may find that somebody has done a will at home and it's not even witnessed by anybody. They may have forgotten to sign at the end after they typed it up. So that's a problem because you would have thought that, okay, I made a will, yes, I have a will, but it is not a valid will. If the document is unsigned or it's not adequately witnessed, or there is a problem with the way the document was signed or witnessed, the court would have to make a determination as to whether this document is even a will in the first place. So examples of problems are where a will has been altered and the alterations have not been signed or witnessed. That's a problem. Where the will refers to a list, but the list has been changed since the will was made, and the list is not signed or witnessed. That is another problem. Where one of the witnesses is an intended beneficiary is also a problem because a beneficiary cannot be a witness to a will. There may be problems with identifying who gets what in the will. So in a will, it is important to use very clear language, clear and unambiguous language. It should be capable of being understood by someone who doesn't know anything about the will maker, who is getting what, and what the wording that is used. You must be able to understand what is in the will. If the wording in a will could have more than one possible meaning, an application needs to be made to the court to decide whether or how we should interpret this will. So I'll give you some examples. So let's say a gift to, go to slide 26, yes. A gift to my family, right? You just have in the will, you have a gift to my family, $10,000. Who is my family? Your family could be an uncle down the road. That is too vague, it is too ambiguous, so you have to be specific as to which family member you want to get what. How you intend to share it. Are you going to say, okay, 2/3 will go to my family member Sonia, 1/3 will go to, so you have to be specific in your will. Let's say you have in your will you have a gift to my nieces and nephews. Does this include children of your half-brothers or half-sisters? So you have to be specific. Does it include nieces and nephews of a spouse or a common law partner? You have to be specific. So you might think, okay, I'm making this will and this is how I'm going to put it, but then there may be problems with interpreting the will when you have passed. Let's say you have a gift to the blind dogs. What is the blind dogs? Is it an organization? You have to be specific. So let's say you would correct that by saying, I give, devise, bequeath to the Blind Dogs Association located at XYZ, just to be specific, okay? You may also have problems with failing to give away everything in your estate. Sometimes with homemade wills, the will maker may give away the assets owned when the will was being made. For example, a house, a bank account, but he or she may fail to say what would happen to the residue of the estate because you may have left out some things. When an attorney makes a will, there is always a clause, what we call the residual clause. It reads something like this. Anything that I do not name in this will will form the residue of my estate, and it will go to XYZ. So the residual clause would capture anything that is not named specifically in the will that you may come into contact with after you have made that will. So the will maker may leave everything to one person, their spouse, but fail to say what should happen if the spouse dies before them. So attorneys at law, you would find sometimes we have instructions to, my client tells me, I want to give my house at Wanstead Terrace to my wife. Should she pass away, I will give it to my son, Troy. So he has made provision for that gift in the event that his wife passes away and she's no longer able to benefit from the gift. So that gift doesn't lapse. It goes to somebody else. It goes to Troy. So if you're making your own will, you may not think about adding another beneficiary in the event that one of the beneficiaries that you want passes away. So some assets jointly held may not pass on the will and legal advice may be needed. So if you own joint property, automatically it's supposed to pass to the other owner. You might want to put in that will joint property that you own jointly and you will it to somebody else, and that's a problem because you can't do that. If you own it as a tenant in common, your share in the property, you can give that away. But if you're owning it jointly with somebody else, that's a problem. You may find problems with storage and security of the will. You said that Sonia, you asked if you can have a will and you keep it at home, but the original will is usually lodged at the court, like I said, for safekeeping. The court will require access to your original will before your estate can be processed. So it is important to keep the document wherever you keep it. If you're making your own will, you have to keep it safe, usually in a safety deposit box. But if you are making a will at home, or even any will in general, it is wise to advise the executor or the person who you have named as the executor where you have it. Because if it is not at the registry and you pass away and you're the only person who knows where this will is, it will be held to find the will. So you have to let at least the executor who you are naming in the will, let them know where you have placed the will for safekeeping. Neil?
All right, so we have another question online. Is the executor aware of the contents of the will before the death of the testator?
That is optional. Okay, so if it's somebody you trust, what sometimes happens is your attorney lodges the will at the registry. You have a copy of your will. You can give your executor a copy of the will, right? You can say, I have named you as executor. Here is a copy of the will that I have made. In that situation, they automatically will know these are the things that I have put in my will and these are the persons who I want to benefit. But there is no requirement saying that you have to tell them what is in the will. You just need to let them know, okay, I have named you as an executor. Do you object? Are you fine with that? Should I pass away, I have lodged the will at the registry, or I have the will in a safe deposit box somewhere at home. This is where you can find it. But you don't have to show them, this is my will. Okay? If you're keeping it at home, make sure it is in a waterproof or fireproof safe in your house. You can also let the person, right, so I have mentioned that. You let your executor know where you have kept the will, because it makes no sense that you make a will and at the time you pass away, nobody can find it. So you would want to have a conversation with them, let them know, okay, I've named you as a will. If there's a safety deposit box, this is the password. When I pass away, you can always access it and retrieve the will. Like I said again, it is wise to duplicate signed copies so that you can give to the executor or your attorney at law should you pass away. The signed copies can be used to establish your intentions in the case where the original will is destroyed or lost. So sometimes situations arise where we have a will, but it is destroyed. So you have the copy of the will, but you can't find the original. I have had to deal with a matter where I had to apply for the copy of the will to be deemed as the original will, because the executor could not find the original will. It wasn't lodged at the registry, but they had a copy of the will. So, yes, the absence of the original will can complicate matters, and it could just prolong the entire probate process. It takes longer for your estate to be settled. Yes.
Sorry. You talked about lodging the will at the registry. Suppose I have the will, I made the will, only one copy, lodged it to the registry, and the registry burns down. Who is responsible? Because you talk about the problems and you say your estate is likely to pay substantial legal costs in order to resolve that problem. Is it the government's responsibility to resolve the problem at that point in time, or your estate?
I believe it would be the government.
Thank you.
Because if you have lodged it for safekeeping somewhere, you expect it to be kept safe, not so? I think the registry has things in place such as fireproof cabinets and so forth to store wills. So it might the registry might burn down, God forbid, but your will might very well still be safe. But if there's a problem and you have already lodged it, that is not at you. That will be for the registry to sort out, but that might take a while. Yes, Sister Sonia?
Okay, we talk about wills, and can you record a will? Record
No,
a will.
it has to be handwritten, typed.
As executor of a will, how do someone go about executing that? Do they have, and what timing, right? Do they have to have an attorney? Because suppose it was executor of Sister Francine's will, and they say, well, she left the dog food for the cat, right? At what time do I give it to the cat? Do I have to have an attorney while I'm giving this to the cat, or somebody in the presence of me giving, giving these things? How?
Okay, I will go through the probate process just now, but usually there is an attorney involved who makes an application for probate. Now, what that is the application specifically to the court to say that I am the named executor in the will of XYZ, and I am applying to obtain what we call a grant of probate. With that document, the executor has to file an affidavit, and you have to file an affidavit of value to say this is the value of the estate. You also have to file the affidavit for the witnesses and all of that. So it is advisable that an attorney at law does it for you, because there are certain documents that must be filed. Then the attorney at law can follow up with the registry to make sure that the grant of probate is ready. But in terms of timelines, there is no specific timeline for the executor to probate your will. However, the beneficiaries may want to have you, as the executor, probate the will as quickly as possible so that they can access the funds. Let's say somebody is named as an executor and they are dragging their feet. They don't want to go to probate the will. They're taking years to do it. You, as the beneficiaries, you can collectively petition the court to ask that somebody else be appointed as the executor. So you're clearing off you as the executor. You're clearing you, and you're asking that somebody else be appointed to obtain a grant of probate to administer the estate. Okay?
One quick question. Is there something called a deathbed will? I've heard somebody talking about the person knows that they're going to die or whatever, and they decide to make this will in the presence of the nurse or the doctor. Is there such a thing?
I don't know of a deathbed will, but once that person is of sound mind, they are understanding that they're making a will, that they understand that these are the things in the will and this is who I'm giving it to, and the witnesses sign,
So the nurse or the doctor can actually sign it, or they can write it for the person too.
Sister Francine might have something to say there.
Go ahead. Go ahead.
I think with the deathbed will, I'm speaking on the correction, the person has to be of sound mind.
Yes.
And by the way, the laws in Barbados have changed a bit, so it's not any old doctor. The doctor has to be a psychiatrist to determine the person's of sound mind. And then Shamora mentioned in her presentation as well, the person can direct you what to write once all the other conditions are made or are met. The persons can direct somebody else what to write, what to annotate, and so on. And once all of the things, the conditions are met, then it can be a valid will.
Yes, that's correct. So, yes. It doesn't have to be in your handwriting, right? So I think that answers the question. It doesn't have to be in the person's handwriting. Once it is in writing and you're still capable of understanding that I am making this will, I know who it's going to, I am of sound mind, and it is signed by 2 witnesses at the end, it's a valid will. But that is caution, because it can always be challenged by persons who may say, oh, she was forced to make the will. So I would say now, when you're healthy and well, might be the best time to do it. It's a valid will, but it can be contested. Okay, so we have a question.
All right, so we have another question from the online. How accessible are stored wills to registry personnel? How accessible are they to registry personnel?
Well, I can't speak to that question because I am not a registry personnel. However, I know for us attorneys, to access the will, we have to fill out a form and we take it to the registry. And what happens is the clerk will come back with the will in a sealed envelope. So I presume if we as the attorney or the person who is going to retrieve the will, if you notice that the envelope has been tampered with, you can raise questions with the registry as to why this envelope looks like it's been tampered with. But it's not supposed to be accessible. Once we have lodged it, it's supposed to be kept there. But I can't speak to that because I am not employed at the registry. All right. Okay. So please note, if we have a question? Okay. If you make your own will, be aware that there are problems. Like I said, the problem may be discovered when it's too late for you to fix it. It may be necessary to make an application to the court to resolve that, and like I said, that might be very costly in the end. And then that means that there will be a delay in dealing with your affairs. Your beneficiaries can't access it if there's a problem to be resolved, because you have to make an application to the court. The judge has to hear the matter. That may take a while, and it may take longer for them to get into your estate and benefit from it. Right. I'm not sure if Greg would be able to pull up. I have a sample of a will here. I don't know if you would see it. So while Greg does that, I think we have another question.
Yes. Does a will that is not done by an attorney still have to be probated with the court?
Yes, any will that you make has to be probated. You can't administer or you can't access the assets or whatever is in the estate unless it is probated. So I'm going to come to that in a minute, but I just want to show you how a will looks. You have to go through the court to obtain what we call a grant of probate in order for you to do anything with the estate. We have another question?
Yes, I have a few before you go on. So you can answer yes or no to some of them. Can you have a joint will?
Yes, you can.
Okay.
That is usually done by a husband and a wife, but you can have a joint will.
Okay. So you spoke about you can have more than one executors. Mm-hmm. When you have more than one executors, you have to have them with priority ranking?
No, you don't. But For instance, let's say you have let's say you have a complex estate. When I say complex, meaning you're very rich and you have different portfolios, different assets. You can have an executor to deal with some of the stuff, and you can have one to deal with the other things. So let's say you want your accountant as your executor to deal with whatever investments you would have made. You can specifically say in the will, I appoint my executor, Reverend Jones, to as my accountant to deal with these specific things, right? So you can have different roles for the executors, and you can say any other thing, my executor, Greg, would deal with any other matters. But you can specifically say if you want your executor to deal with one thing. The good thing about having more than one is that should one of them pass away, you have the other person who can still function as your executor. Or if it is a complex matter and you want to get the estate administered quickly, one can work on something and the other can work on another.
Okay. Which brings me to, do you have to pay the executors and the trustees?
No, you don't. You don't have to, but if you are kind and you say, okay, Shamora, I want you to be my executor, and because of all the work I know you will have to do, I'm going to leave a little something there for you. But generally, it's you don't pay them. Because most times it's family, you know, it's a relative or something, so you don't have to pay your executor.
Right. If your executor or the trustee or a beneficiary is suspected of foul play, how do the courts deal with that?
Right. So because it's a what we call a fiduciary relationship, they have certain duties that they should comply with. The estate or your beneficiaries now will supposed to, or they can, make a claim against the trustee or the executor for them to account for certain things. If you think that there's misappropriation of funds, or if you think that there's some foul play, you can call upon the executors to account for what you suspect, right?
But that would be other beneficiaries because I'd be gone.
Yes, you'll be gone.
Right. Then I think earlier on you said that the beneficiaries now have to apply. Is that the case when is through the executor?
Right. So the executor applies on their behalf.
Okay. Okay. What happens to the estate if the matters haven't been sorted within 6 months?
Sorted as in?
It has to, the application has to start within 6 months, not finish resolving.
No, it doesn't have to be started. The spouse has to take whatever they get in the will. They should access it within the 6 months after the grant of probate.
Oh, okay.
But there's no timeline for the executor to apply for probate.
Oh, okay.
But like I say, if you find that the executor is taking too long, you as the beneficiaries can take action.
Okay.
Right?
So, for example, if I find out that I didn't know this person had any money, but 5 years after I find out that there was actually a will with something, it would still be valid?
Yes.
All
but
right.
the gifts might lapse, but it's still a valid will.
Okay. Last question for now. How does the jurisdiction apply to wills? If I have properties in more than one countries, because I know that sometimes they're different.
Yeah.
So how does that apply? Should I make different wills in different countries?
Okay, so there's this process that we call resealing. So within the Commonwealth, if you have property in more than one, let's say more than one Caribbean country, let's say most of the property is in Guyana, but you have property here in Barbados, you can make one will that takes care of property in Barbados, Guyana, apply for probate in Guyana, and have it resealed here in Barbados. So what it means is you apply for the probate, you get the grant there, and then you come to Barbados and you go through a short process. Well, I don't know if it's short here. A process called resealing, where you present the grant that was already given. So you're basically telling the court, I have a will, the executors will be telling the court, we have a will, we have already obtained the grant of probate, and we're asking you to reseal it, meaning now give us a grant for the assets we have here in Barbados. We have already gone through the process, it just needs to be resealed. All right, so I don't know if you can see on the screen, but this is a sample of a will. Basically, Greg, you can zoom it a little or just increase the font. Sorry, Denise, can you increase the font? All right, so it says, I married Joe of Chalky Mount in the parish of St. Andrew in the island of Barbados, being of sound mind. And let me pull it up here because I can't see so far.
And memory and conscious of the uncertainties of life.
Right. I, Mary Jo of Chalky Mount in the parish of St. Andrew in the island of Barbados, being of sound mind and memory and conscious of the uncertainties of life, do hereby make and appoint and publish and declare this to be my last will and testament. Prior to the execution of this will, I have not made any will or codicil, and if there be any such will or codicil, I hereby revoke the same and declare this to be my last will and testimony. So this is a standard first paragraph of a will. So here she's saying that I want this to be my last will, and if I made any before, I am now revoking those within this first paragraph. So if you're making a second will, you have to revoke the first one. So this will do that. She then says, I hereby appoint Jane Doe of Hidden Crest, Sugarland, Texas, something, to be the sole executor and beneficiary of this will. So she has no other persons who she wants to benefit here in this will. I direct that my executor shall first pay all my debts and liabilities out of my assets, all of my expenses and all of my funeral expenses. So what you would find is the executor has to pay all of your funeral expenses before they administer anything else in your estate. They have to pay funeral expenses, but usually that is done before. Okay, so for instance, you may have a bank account, somebody is the executor, and you go to the bank and you tell them, you present the death certificate and you tell them, this person has passed away, I need to access some of the funds to bury that person. Some financial institutions can give a lot of trouble. Some of them may give you some of the funds to help you bury the person, but some of the funds may actually have to come from elsewhere because probate may not have been finished by the time that person is being buried.
Question.
So then you have to now either pay back yourself if you would have taken the money from your funds to bury the person, but you have to make sure that your funeral expenses comes out from that. You have to pay back people.
Question. No. What you just said is very interesting. So, I have a will that says my funeral expenses should be paid by my executor. But I died last week, and I'm to be buried tomorrow.
Right.
Nobody knows who the executor is
Yes.
at that point in time.
Yes.
Can the funeral home find out from any one of my relatives if I have a bank account and approach the bank or somewhere to say, please send them the certificate and say, could you pay for this funeral because this person has money in their account to do it?
A funeral home can't do that. But as the relative, you can probably do it. I had a client once where his mom passed away. He knew that there were funds in an account, and he asked the financial institution. He was not a joint owner on the account. So, of course, there are certain rules that apply to financial institutions that they can't disclose information on an account. But he was able to explain to the bank, this is the death certificate of my mom. I know she has funds here, and I need to access some of it for the funeral. So what they would have done is they gave some of the funds, and they instructed him that upon obtaining the grant of probate, he has to bring it back so that they can be sure that the monies went to the funeral, for sure. So basically, it depends on the financial institution. Some institutions give you no money at all, and you as a relative will have to foot that funeral bill, and then when the estate is probated, you take this directive that is given here for you to pay any funeral expenses. If it is you took it from your funds, you would have to be reimbursed. This clause gives you the authority to reimburse, to be reimbursed for any funeral expenses.
So any relative could take the lead on that, or it has to be, for instance, if it's a man, his wife, or his children, or could it be my second cousin, third cousin, fourth cousin?
If that person knows that he's named as an executor, he can go. That would make it so much easier. Like I said, the banks, I may give you this advice and then you go to one financial institution and tell you something different. But I know for the client I had, he was the executor named in the will, so it was easier for him. I don't suppose any bank will just give any person any funds, even though they just present the death certificate. They need to be satisfied as well that this person is probably the executor. You may need to bring a copy of the will to say, I am actually named as the executor, but the will has not been probated as yet.
And so if there is no will, that process gets even more difficult.
Yes, correct. Because now that person has died intestate, and the first person who is supposed to go, if that person is alive, is your spouse. So if your spouse is alive, that person is the person who is first on the order of priority to apply for a grant of administration, letters of administration, which is a different name, but because they have died intestate, they get a grant of letters of administration. Letters of administration. Right. So that person will be who the bank will expect to come. They will ask, did the person have a will? Who are you to the person? You may say, this is my spouse. Can I see your marriage certificate? Can I see the death certificate? And they may ask you for a lot of other things. So each financial institution is different. But it would be the spouse, then any children would be next, and then any relatives that you have, like let's say a mom that is still alive, or any siblings.
Okay, thanks.
Okay, so the probate process. Oh, right. So that will, she made provision for the funeral expenses to be taken out. And in this case, it seems as though she has one property at Sugar Mill and she gave it to that person. All right, so let's go to the next slide. How to probate. So when the executor is told that they have been appointed as the executor and they know that the person has passed away, they have to, they should consult an attorney to make an application for a grant of probate, right? So before applying, you would have to speak to the person to find out if they even need a grant of probate, whether they find out if they're eligible to apply, and whether they would have to pay any dues or taxes. You let them know about that. So you would have to, as the attorney, contact the financial institutions for the person to find out if you need to have a grant of probate, because like I said, sometimes persons would have had named a beneficiary in your account. If a beneficiary is named, then you don't have to get a grant of probate to access that account. So you will ask questions like that. Every organization has their own rules. I am sorry for that slide. You may not need a probate. You may not need probate if the person who died only had, right. So you may not need probate if the person was a joint owner in an account. That automatically goes to the other owner. But I forgot to tell you what probate is. I'm so sorry. So probate is the legal right to deal with someone's property, money, possession, what we call their estate when they die. So an executor is the person who would apply for that, and they now have the legal right to deal or to get in or to administer an estate. An executor should not deal with someone's estate until he has obtained a grant of probate. So even if you're named on a piece of paper as the executor, if you don't have that document from the court, you can run yourself into a lot of trouble if you start meddling in the people's affairs without the grant of probate. So you check to see if you have to apply for probate. Now, the process for somebody who dies without a will is different, like I said. When somebody dies without a will, the attorney comes on board and we send letters, we contact all the financial institutions to find out if you own any accounts at any of the banks or wherever. We check to see if you have land anywhere or any assets, so that we can know what exactly is in the estate, because without a will, we don't know what you have to give away. So we do that. We call in the estate, and then we update the person who is applying, which is usually the spouse first, and then the children. You let them know, well, okay, we found that your mom had $1 million at Royal Caribbean, and you tell them what the value of the estate is. So only certain persons can apply for probate. Like I said, who can apply depends on whether or not there's a will or not. So if there's a will, it will automatically be the executor who is named in the will. That person will apply. And if there is no will, then it will be your closest relative, which would usually be your spouse and then your children. So in Barbados, clients usually ask how long the process will take. And we always find ourselves in a difficult predicament because things take long here. At first, I wasn't sure why. When I just came, I came in the middle of COVID. So a lot of the reason was because of COVID, things are backed up. But we, as attorneys at law, always find ourselves in difficult positions because clients want to know how long will it take for me to get this grant, and we can't tell them because it all depends on what is done at the registry. Once we lodge the application, we follow up continuously. I've been told before that it takes 3 months. It should take 3 months, but in reality it does not. So persons, you would find that they've made an application for probate and they're waiting years to get the grant so that they can administer their loved one's estate. And you can imagine if persons are waiting to benefit from an estate and they have to wait years, and they're constantly calling you to ask what is happening, and you telling them you're checking, and you can't give them an answer because you don't know when the registry is going to come back with the information that you need. So it's just a reality that we're dealing with here in Barbados. So if an attorney tells you, I don't know when you're getting your grant, most likely they do not know, but they are checking. Well, I can speak for myself. So we usually wait for the grant of probate, and then when we get the grant of probate, that executor is able to get into the estate. Now, after the grant has been obtained, you, as the executor named in a person's will, you are legally responsible for any monies, any property, any possessions that the person would have died with. So it is a great responsibility that you don't take lightly. At any point in time, the beneficiaries can call upon you to give an account. What did you do with the money? Where did you spend it? Where is the property at XYZ? Why are you not selling the property so that we can benefit from? So it's not a light job when somebody asks you to be an executor. You are responsible for the assets from the date of death until the date everything has been passed to the beneficiaries. So you have a lot of work to do in there. You may have to sell properties and distribute the assets among the beneficiaries. So just letting you know, it's not an easy job. So this period between time of the person's death and the time all of the assets are given away is known as the administration period. And within that period, you may have to pay any debts, like I said, left by the person. You may have to sell properties or shares. You may have to pay any outstanding taxes or anything like that from the estate. You may have to report on the value of the estate, and you, at times, it is advisable that you set up a bank account known as the executorship account if needed, because what happens is any funds, you don't want to intermingle funds. You would have your own personal account, bank account, and any funds that is due for the estate should never ever go into your personal bank account. So you would find persons would open what we call an executorship account. So any funds belonging to the estate goes there, and persons can account for the monies within that account. Yes. And that brings me to the end of my presentation. I will encourage any other questions now.
All right, the question is based on the executorship account. So if the person that died had, I'm just calling a number, 5 bank accounts, the executor can close all 5 and put the funds from the 5 into one executorship
Yes, they have
account.
the authority to do that.
Oh, okay, okay.
And it is better, I guess you're an accountant, you may know, for accounting purposes, you're able to generate better statements from one account. You can see all of the funds, what is there. Yes, so it is advisable to do that.
One last question. If you have access to somebody's bank account, but you don't own any money on it, but you just have like a PIN, and you have access to a card, and that person dies, is there any legal ramifications that can be had because that person continued to use that card after the person has died? What advice would you give to a person who, after a person has died, and continue to use that person card, knowing that the money is not yours, and you join it off?
What would be the purpose of drawing it off? Is it to bury me? If they're using the money to bury me.
Whether drawing it off to bury the person, you're not the executor of the
if you're not the account holder on an account, or your name is not on an account, you should not be accessing or withdrawing funds on that account without authorization to do so. If the person has died, then there's nobody to authorize you, because then that person's estate is who is supposed to benefit from the funds in the account. If you are withdrawing monies from an account that a deceased person left there and they didn't tell you to take it out, you're a thief. Okay? You're a thief. So you should not be doing that unless you have the authority to do so as an executor. Or you have instructions to do so. Any other questions? All right. There are no other questions online.
Can we get a copy of the presentation?
I can amend it for you. I can give you some.
And the sample will, because I have to go with.
Okay, no problem.
Oh, me and my wife have to go with.
No problem. All right. So thank you so much for your time, and I hope that the information that was provided will help you to make better life decisions, and can get you started to think about being good stewards and leaving what assets the Lord has blessed you with to your loved ones in the proper way. All right, so thank you so much. Well, any qualified attorney.
Okay, can we have a round of applause or two for Mrs. Shamora Scott-Springer? Yeah, I thank you, Shamora, for doing an excellent job tonight. We know that we threw a lot of questions at you. That's because we really had those questions. So, we really, really appreciate you taking the time out to prepare. It might just seem like a little presentation here, but we know that there's a lot of work, research that goes into it to make sure that we get the correct information that we need. So we really just want to say thank you for the time and the information. And to those who are online, to those persons who are in our audience, we thank you also for coming out to hear the information that is shared. We have a repository of good information among us, and it's good as Christians to share this. This is how we grow. This is how we prosper. This is how we'll be able to make good decisions for the kingdom. So I hope that those of you, myself included and another person in here included, will go ahead and make your wills. Make sure you make a plan and make it plain. And Shamora is too humble to say it, but if you need help, you don't need to look too far. She has a digital card, so that can be made available afterwards for you to know how to contact. If you want a little advice, you may not want her to do the entire thing, but there is a consultation fee as well, so you can consult and figure out, okay, so how I can do this. So you don't have to pay the whole fee, right? So you can decide you want to do it, but you just want to make sure you do it right. I'm sure that there's a consultation fee that you can, that is much less than that. So go ahead, do well, get home safe, and we really thank you for being here, and we look forward to seeing you at another one of our meetings. Thank you very much.